5 seconds to go. Start. To succeed on that short ground, the appeals are consequently allowed, and the impugned order dated 7th April 1994, passed in the review petitions, is hereby set aside. The respondents shall pay rupees 10,000 as costs. Emphasis supplied. In Kanhayamat's case, Supra, where the SLP was dismissed by an order in terms special leave petition is dismissed on merits, the Supreme Court, while examining the issue regarding maintainability of the review petition before the High Court after dismissal of the SLP in the context of the principles underlying the doctrine of merger, opined that the jurisdiction conferred under Article 136 of the Constitution upon the Supreme Court is special jurisdiction which is sweeping in its nature. It is untrammeled reservoir of power incapable of being confined to definitional bounds. The discretion conferred on the Supreme Court being subject to only one limitation, that is, the wisdom and good sense or sense of justice of the judges. No right of appeal is conferred upon any party, only a discretion is vested in the Supreme Court to interfere by granting leave to an applicant to enter in its appellate jurisdiction not open otherwise, and as of right, considering the two stages of exercise of jurisdiction conferred on Supreme Court by Article 136 of the Constitution. 1. Granting special leave to appeal. 2. Hearing of appeal. The court summarized the legal position as under. While hearing the petition for special leave to appeal, the court is called upon to see whether the petitioner should be granted such leave or not. While hearing such petition, the court is not exercising its appellate jurisdiction, it is merely exercising its discretionary jurisdiction to grant or not to grant leave to appeal. The petitioner is still outside the gate of entry, though aspiring to enter the appellate arena of the Supreme Court. Whether he enters or not would depend on the fate of his petition for special leave. If the petition seeking grant of leave to appeal is dismissed, it is an expression of opinion by the court that a case for invoking appellate jurisdiction of the court was not made out. If leave to appeal is granted, the appellate jurisdiction of the court stands invoked. The gate for entry in the appellate arena is opened. The petitioner is in, and the respondent may also be called upon to face him, though in an appropriate case, in spite of having granted leave to appeal, the court may dismiss the appeal without noticing the respondent. In spite of a petition for special leave to appeal having been filed, the judgment, decree or order against which leave to appeal has been sought for continues to be final, effective and binding as between the parties. Once leave to appeal has been granted, the finality of the judgment, decree or order appealed against is put in jeopardy, though it continues to be binding and effective between the parties unless it is a nullity or unless the court may pass a specific order staying or suspending the operation or execution of the judgment, decree or order under challenge. The Supreme Court, while considering the law laid down in Abai Maligai Partnership Firm's case, Supra observed that the honorable judges deciding the said case have nowhere in course of their judgment relied on doctrine of merger for taking the view they have done. After threadbare discussion of principles underlying doctrine of merger, while referring to various earlier decisions on the issue, the Supreme Court opined a petition for leave to appeal to this court may be dismissed by a non-speaking order or by a speaking order. Whatever be the phraseology employed in the order of dismissal, if it is a non-speaking order, that is, it does not assign reasons for dismissing the special leave petition, it would neither attract the doctrine of merger so as to stand substituted in place of the order put in issue before it, nor would it be a declaration of law by the Supreme Court under Article 141 of the Constitution, for there is no law which has been declared. If the order of dismissal be supported by reasons, then also the doctrine of merger would not be attracted, because the jurisdiction exercised was not an appellate jurisdiction, but merely a discretionary jurisdiction refusing to grant leave to appeal. We have already dealt with this aspect earlier. Still, the reasons stated by the court would attract applicability of Article 141 of the Constitution if there is a law declared by the Supreme Court, which obviously would be binding on all the courts and tribunals in India and certainly the parties thereto. The statement contained in the order, other than on points of law, would be binding on the parties and the court or tribunal whose order was under challenge on the principle of judicial discipline, this court being the apex court of the country. No court or tribunal or parties would have the liberty of taking or canvassing any view contrary to the one expressed by this court. The order of Supreme Court would mean that it has declared the law, and in that light the case was considered not fit for grant of leave. The declaration of law will be governed by Article 141, but still the case not being one where leave was granted, the doctrine of merger does not apply. The court sometimes leave the question of law open, or it sometimes briefly lays down the principle may be contrary to the one laid down by the High Court, and yet would dismiss the special leave petition. The reasons given are intended for purposes of Article 141. This is so done because in the event of merely dismissing the special leave petition, it is likely that an argument could be advanced in the High Court that the Supreme Court has to be understood as not to have differed in law with the High Court, emphasis supplied. Stop.